All right, everyone. Thank you all for being here. Welcome to all of you here in the audience, and welcome to all of you on Zoom as well. My name is Stephen Scoltetti. I'm the director of the Declaration of Independence Center for the Study of American Freedom. The mission of this center is to ensure that the University of Mississippi students and faculty have an opportunity to explore the nature of freedom in America, as well as the sorts of constitutions, laws, policies, and norms that support or hinder freedom. I hope you'll take some time to visit the center's webpage, and please don't hesitate to reach out to the center at our email address, freedom@olemiss.edu. So here's a fundamental question. Why do we bother with a constitution? I mean, what's the point? What's the purpose of living under a constitution instead of simply being ruled by government? The basic answer to that question is that while we might disagree with this decision or that decision that the government makes, a constitution gives us some assurance that the kinds of things that government is doing, that is, the powers the government is exercising, are the ones that we expect and accept. So, for example, you may disagree about this tax or that tax. You can still accept that government has the power to levy taxes. And you may disagree with this way or that way that the national government regulates the business taking place between states. But you can nevertheless accept that government has the power to regulate interstate commerce. So in other words, yes, government might end up constraining you in lots of ways, but at least it's not exercising arbitrary power over you, exercising any old kind of power it happens to think best in the face of this situation or that situation, in the face of this emergency or that emergency. The old-fashioned term for this sort of relationship between citizens and government power was Republican freedom. And given that, you can understand why James Madison was so confident that the American Constitution was, in fact, a Republican one. After all, in our Constitution, the national government could only exercise enumerated powers that the people had agreed to. So it's in this way that a Constitution can guarantee freedom. And it's in this way that our United States Constitution, even aside from the Bill of Rights, plays a key role in American freedom, the very sort of thing the Declaration of Independence Center is interested in. All of this then brings us to today's event. Is a federal vaccine mandate constitutional? Notice that in asking that question, we're not asking whether vaccines are good or bad, or even whether vaccines should be required or not required. Today's discussion deals with who gets to make that decision. In particular, we're asking whether this kind of action, this particular exercise of power, is granted to the federal government in our Constitution. To help us answer this question and to talk through this question, I'm happy that I invited Aaron Rice. Aaron currently serves as the director of the Mississippi Justice Institute at the Mississippi Center for Public Policy. After the September 11th terrorist attacks, Aaron felt called to serve his country. He joined the Marine Corps and was deployed to Iraq with the 3rd Battalion, 25th Marines, the battalion that suffered the highest number of casualties of any in the Iraq War. Indeed, Aaron received the Purple Heart for sustaining combat injuries. So actually, before I say anything more, let's take a moment to thank Aaron for his truly incredible service to our country. Upon returning home, Aaron earned a degree in political science from Mississippi State University. And then, after receiving a Truman Scholarship and pursuing graduate studies, he went on to earn his law degree from the University of Mississippi School of Law. Then, prior to joining the Mississippi Justice Institute, Aaron built his career as a successful litigation attorney. He is a fellow of the American Board of Trial Advocates, National Trial College at Harvard Law School, and he's a graduate of the International Association of Defense Counsel Trial Academy at Stanford Law School. So please, everyone, join me in welcoming Aaron as we begin our conversation about the constitutionality of federal vaccine mandates.
Appreciate those kind words, Stephen, and I'm really excited to be here with all of you. Like Stephen mentioned, I graduated law school here at Ole Miss back in 2011, and so it's just such an honor to get to come back and actually, you know, be on the other side of the podium. So anyway, thanks for having me, everyone. What Stephen and I talked about doing for this is really just doing some very general concepts about the constitutional issues at play here. So not necessarily, you know, diving into, you know, trudging through 200 years of case law with you and getting into all the nitty gritty, but really just, like Stephen said, kind of the basics, you know, who can do what when it comes to vaccines. And so one caveat I want to make too, and Stephen touched on this, about this not being, you know, whether vaccines are good or bad. I'm personally very pro-vaccine. I've been vaccinated. My wife has been vaccinated. If and when the vaccines are shown to be safe and effective for kids, our kids will be vaccinated. So I just want to say that again, just like Stephen said, this is not about whether vaccines are good. It's about whether the government, the federal government in particular, has the power to require U.S. citizens to be vaccinated. And so one last caveat I want to give too is that a lot of different types of mandates have been kind of thrown around and tossed around here. And so for one thing, we haven't even seen, you know, what the federal government is going to come out with. So in some ways, we're talking in generalities about what might happen. But another thing to just caveat is that I'm going to be talking about not if the federal government requires its employees to get vaccinated, which is a very different question, or the federal government using, you know, federal dollars to incentivize hospitals to require their employees to get vaccinated. That's also a very different topic. We're going to talk about what y'all have probably all heard about, the OSHA, you know, can the Department of Labor require companies to require their employees to get vaccinated? So that's what we're going to talk about. Now, I'll just cut to the chase. You know, Stephen asked the question, can the federal government, or is it constitutional for the federal government to have a vaccine mandate? And the answer to that is no. That's my answer to that. And you know, we don't really know a lot about vaccine mandates when it comes to Supreme Court law. And so I'll start with what we do know for everybody. And so the first thing we know is, what if a state tried to have a vaccine mandate, not the federal government, but the state of Mississippi? And we know from, you know, the U.S. Supreme Court precedent we have that probably would be constitutional. And so we've actually got, I said I wasn't going to trudge y'all through, you know, hundreds of years of case law, but I'll talk about a few cases along the way. And we do have a case right on point on that. It's called Jacobson versus Commonwealth of Massachusetts. It's from 1905, and it dealt with smallpox. And nothing is new under the sun. You know, Massachusetts imposed a vaccine mandate, or allowed cities to do that. And then Cambridge went ahead and did that. And there was a pastor there who didn't want to be vaccinated. He had some adverse reactions to the vaccine, to other vaccines when he was younger. And so that went all the way up to the U.S. Supreme Court. And the U.S. Supreme Court said, yes, the state can require a vaccine. And so now there's some important caveats there. I mean, in that case, we were talking about a small fine for not getting the vaccine. It was $5. So we're talking about today about $150. We're not talking about forced vaccination. We're not talking about imprisonment for not getting the vaccine or anything like that. And there's some other exceptions there. I mean, you probably today have to have exceptions to that state vaccine mandate for people that had health conditions that prevented it, or for people with sincerely held religious beliefs, because that case, I won't get into why, but did not deal with that First Amendment issue. So we know that. That's what we know. That's really all we know when it comes to state or just government imposed vaccine mandates. So when it comes to the federal government, that's never been tried. The federal government has never tried to impose a vaccine mandate. So what do we know? We got to back up and say, what do we know about it in general? Well, the first thing that I think you need to understand why the federal government can't do this is the relationship between state governments and federal governments. And I think that a lot of us understandably get this confused. A lot of times we think of the federal government up there in Washington, D.C., that big government. They're kind of like, you know, the big boss of America, the CEO of America. And the states are kind of like the regional managers of America. And the localities are kind of the assistant regional managers, or maybe it's the assistant to the regional manager. I don't know if the office is still a thing these days or not for college students, but the fact is it's actually kind of the exact opposite of that for most things that really affect your life on a day-to-day basis. So things like running your schools, or combating street crime, or zoning issues, and really a lot bigger issues that we're going to talk about with the things like vaccines too. So the Constitution sets up the federal government and gives it very limited, specific, and enumerated powers. And it is a government of limited power. The federal government has to point to some power that it's granted in the Constitution for anything it does. And those powers really are, again, very limited and expressly stated in the Constitution. So you've got things like the federal government is in charge of national defense, or foreign relations, or immigration, or coining money, or commerce among the states. And that's going to be a big one that we're going to talk about today. And so even after just granting the federal government those very enumerated specific powers, the Constitution later in the 10th Amendment, the framers made clear again that the federal government was very limited in that way by saying in the 10th Amendment that the powers that were not granted to the federal government were reserved to the states and to the people. And so one of those powers that's reserved to the states is what's known as the police power. And that is just the general power of a government to regulate for public health and safety and morals and general welfare of society. I mean, it's a very, very broad power. And it doesn't come from a constitution per se. It comes from common law and ancient traditions, and we've all just accepted that that's the power of government. It's really the broadest power that the government has, and that power, the states have that. They don't have to necessarily even, again, point to anything to say they have it. They just inherently have it. The federal government does not. And so when you get into something like a vaccine mandate, well, then if the states have the right or the power, not the right, the power to regulate, for health, then how is it that the federal government is thinking about doing that? Well, that goes back what I mentioned earlier, commerce among the states. That's the Commerce Clause of the U.S. Constitution. And so let's back up and say, why do we have a Commerce Clause? Okay, so before we had a constitution, after we'd won our independence and we were operating under the Articles of Confederation, we had a very, very weak national government. Even, I talked about how the federal government now is limited. I wouldn't necessarily describe it as weak, but it's limited. The federal government under the Articles of Confederation was a very weak government. And one of the problems we had was that the states that we had at the time were setting up protectionist trade barriers between themselves. And it made it to where you really couldn't have a functioning national economy that way. And so that was really one of the prime motivations of having a new constitution, was to deal with that problem. And so I think you just have to ask yourself, first of all, is that what we're dealing with a vaccine mandate? Are we dealing with, protectionist trade barriers among the states? Obviously, no, that's not the issue. But the Commerce Clause has been, as our national economy has grown to be so big, the Commerce Clause has kind of grown along with it. I think probably a lot more than it should have, but the Supreme Court has interpreted it to be very broad and to grant some very broad powers to the federal government. And so just to give you an idea of that, it's not just commerce that's actually happening between the states, but the channels of interstate commerce, the people and things in interstate commerce, and even the activities that substantially affect interstate commerce. Now, remember that word activities, because that'll be important later too. But just to give you an idea of how broadly that's been interpreted by the Supreme Court, there was a case, again, I said I wouldn't go into too many cases here, but there was one where the federal government wanted to help prop up the price of wheat. And so one of the ways they wanted to do that was to limit the supply of wheat. And they told farmers, using their Commerce Clause power, you all have a quota, you can only grow this much wheat. Well, there was one farmer who was growing more than that amount of wheat on his farm, He was not selling it in interstate commerce. He wasn't even selling it at all. He wanted to grow it just for his own personal consumption and to feed the animals on his farm. Clearly not engaged in interstate commerce. But the U.S. Supreme Court said that it was constitutional to apply those controls to him, because in the aggregate, if you took everybody like him, if everybody else did what he was doing, that could substantially affect interstate commerce. So if everybody grew their own wheat, then it would, it would, less people would need to buy wheat, the price would go down, all of that. So that's probably, kind of, and I think that was a bad decision, but that's probably the outer reaches of where you get on the Commerce Clause, how it's been interpreted. And you can see from that just how broad it has been interpreted and how much the federal government has been allowed to do using that power. But there are still limits, even with how elastic the Commerce Clause power has been interpreted, there are still limits to it. And I think the best example of that, and very recent too, it's actually, just very similar to what's happening now, was the Obamacare decision, from about a decade ago. And so with that, you had a very similar thing where the federal government was imposing a very novel, never been done before mandate on U.S. citizens, and saying you have to buy health insurance. Again, federal government had never tried that before, and so the U.S. Supreme Court had to take a look at it. Now, how did the federal government defend and say that it had the power under the Commerce Clause to do that? Well, it said again that affecting interstate commerce language that the Supreme Court had used before. It said, look, what we have here is a problem of cost shifting. People who don't get health insurance, inevitably they need care. If they're not insured, then they may not be able to pay for it. Hospitals provide uncompensated care. Then they shift the cost of that uncompensated care onto other people by raising insurance rates. And so people not getting insurance affects interstate commerce. And so we have the ability to regulate that. Also, just by getting younger and healthier people into the risk pool, we can help lower the price, again, across state lines for insurance. So that's why we have the power to do this. But there were a couple of problems with that. And so ultimately the Supreme Court held that the federal government did not have the power under the Commerce Clause to have an individual mandate. Now you may be confused because you may be thinking, I thought Obamacare survived judicial review. It did, but Chief Justice Roberts kind of saved the day by deciding that the individual mandate was actually a tax. It was not a mandate. It wasn't a mandate that you have to get insurance. It was just saying, if you choose not to, you're going to have to pay a tax. Importantly, we're not going to be dealing with that here. I mean, Congress has not authorized some tax that the IRS is going to enforce. So it's a very different situation here. So, the problems that the Supreme Court saw in that argument was that, first of all, I mentioned to you that, remember the word activity, activity that substantially affects interstate commerce. Well, when you impose an insurance mandate, you're really trying to regulate non-activity. That's the whole point. You're saying you have failed to buy insurance and we want to compel you to engage in economic activity. And the Supreme Court said, look, the federal government does not have the power under the Commerce Clause to compel economic activity. And, you've really got the same exact issue with a vaccine mandate. I mean, the whole point is that somebody has failed to do something. You're compelling them to engage in activity they haven't already engaged in. And then another problem really that you have here that's even worse than what you had in the Obamacare opinion is that this isn't even economic activity. At least purchasing insurance, it was non-activity, but it was at least economic. Here, you're talking about just a healthcare choice. It's not even economic either. So it's not activity and it's not economic, and it's not crossing state lines. So and another problem that the Supreme Court pointed out with the insurance mandate was that there was no limiting principle there. So if the federal government, using its Commerce Clause power, could say, well, people not having insurance raises healthcare costs, so we can regulate that, then you could say the same thing for, well, people having bad diets, makes people sicker, raises healthcare costs, so we can force people to eat broccoli, and of course, if the federal government under its Commerce Clause power can force all of us to eat broccoli, then we certainly do not have a limited federal government. And so I think you've got the same problem here. If the federal government can impose a vaccine mandate under that rationale, then you really don't have a limiting principle there either. So one thing I just want to mention, I think the Commerce Clause problem is the problem that most people have focused on. But just briefly, there's also a whole separation of powers problem with the way this is being teed up, at least. And so, when I talked about the Commerce Clause, I may or may not have said, I think I probably did talk about Congress's Commerce Clause powers. And that's very important because, the Constitution gives Congress the ability to legislate, to pass laws under the Commerce Clause, and the executive branch has the power to enforce those laws. And, that's not what's happening here. The Congress is not passing a federal vaccine mandate. You've got the Department of Labor and, OSHA, a division of it, is going to promulgate a rule to do this. And so, defenders of that process will say, well, Congress has delegated its authority to write that rule, to pass that legislation, has delegated it to an executive branch agency. And so, the question is that true? Would that be upheld? And I think the answer, again, is no, because number one, Congress can't delegate powers that it does not have. And so, that ties into what we've already discussed, that the Commerce Clause power does not authorize this to begin with. But then secondly, even if it was, proper under the Commerce Clause, the act that we're talking about really does not authorize the Department of Labor to take such sweeping actions as imposing a vaccine mandate. We can talk about that in the Q&A some. Stephen and I talked about trying to reserve most of this time for Q&A. But the biggest reason why is just that the Occupational Safety and Health Act allows the Department of Labor to regulate the workplace to make it safe. What this would be doing is really regulating the lives of individual employees and telling them that outside of the workplace, they've got to go make a healthcare decision, one that they may be adamantly opposed to, which is that's a sweeping, broad power that is well beyond anything that is really contemplated in OSHA. So one last thing I'll say before we can kind of move on to Q&A here is just on the separation of powers issue. I think when I've talked to people about this in the past, some people think that's kind of a technicality, like who really cares? We're in a deadly pandemic. Who cares who takes the lead on a vaccine mandate, whether it's Congress or, the Department of Labor, does it really matter? And my answer to that is that it matters a lot. And that's why it's in the Constitution, is that, Congress is made up of elected representatives that we all elect. When they deal with our rights, they know, and really here we're talking about powers, but either way, their powers and our rights, they know if they abuse their power, then we can throw the bums out, and that's very important. When you're talking about the executive branch, that's made up mainly of kind of unelected bureaucrats who don't have to worry about that. And so the founders very much wanted for Congress to be the one that had to have their feet to the fire and pass important laws like that. And then, even if you say, well, this is really the president is directing an agency to do this, it's important for the very same reason. And, we don't want our president to be able to be essentially a dictator and just decide these kind of fundamental issues for all of us on his own. So with that, I'll open it up to Q&A if anybody has anything. Yes, sir. Appreciate that.
Day for technically was a student at the University of Mississippi Medical Center in Jackson, Mississippi. My wife and I are both ICU nurses in Memphis, Tennessee, and I'm a former police officer as well. So I come to you with a question and maybe guidance for help. This semester, I've been halfway through UMMC. I'm an RN. I'm getting my BSN. I finished halfway through the program. Classes began on August 16th. On August 20th, UMMC issued a mandate for students. So you're already enrolled in classes. You've already paid money. August 30th was the last day to receive a refund and withdraw with the W instead of receiving any leave. So long and the short of it is, I emailed the dean of my program, stated that I had a religious, conscientious, and moral objection to this mandate, and asked if those would be looked at because there was no information and it stated it would come to follow. She said, conferred with her boss, there's no guarantees. your best bet is to withdraw from the courses. I went ahead and withdrew from my courses, told her that I would be applying for an exemption and continuing my courses or looking elsewhere. They withdrew me from the course, from the program completely. Completely withdrew me from UMMC, or in the BSN program. I was told to follow up with them and, had radio silence the entire time.
Sorry, I don't want to put you in a position to give you legal advice.
I was going to mention that, but
Program, and she did not, spend thousands of dollars there and will lose thousands of dollars.
yeah,
And so, you know, do you recommend an attorney that I can reach out to?
yeah. We're going to talk about that offline too, and I can leave my card with Stephen or you to kind of get up in terms of referrals and things like that. Stephen's absolutely right. I mean, I don't want to necessarily give legal advice to your exact situation, but I'm happy to talk kind of in generalities through some of those issues that you're talking about. And first,
For the people listening on this,
Yeah.
could you maybe just repeat? You'll have to repeat.
oh yeah, the question. Yeah, I'll briefly summarize by saying that we had a question that someone worked for UMMC and there's and is taking classes at UMMC, and there's a vaccine mandate there, and he's got a religious objection to that and is being withdrawn from classes and kind of trying to figure out what to do. So first thing I'll ask though is do you know if there's a testing way past that and that could kind of relate to with the federal vaccine mandate that we're going to talk about too. It may come up in the Q&A, but do you know, is it possible that if you don't get the vaccine, you could be tested every week? Okay. Okay.
Boys will wear the N95 respirator mask.
Yeah.
They removed that 100%. They did keep it in the religious exemption, but it came out September 24th that part of it removed.
Okay. Let's talk afterwards. Just in general, I mean, religious exemptions, I mean, that's something you can pursue. I would say just in general for everybody that's, that can be difficult to establish. I mean, if you've been getting vaccines your whole life until now, that can make it difficult to establish that you've got a sincerely held religious belief that prevents you from getting this. And then, but in general too, we've talked about the federal government and the powers that the federal government has. None of that applies when we're talking about private employers. Now you're talking about UMMC, which, you've got some overlap there. But I would say let's talk afterwards a little bit just about the specifics of your situation. And also too, I'd like to know a little more about the virtual situation, because if you're 100% virtual, that seems like you've got, maybe some issues there with whether it's really even required for you to begin with. I don't know. And if they also, if there's been a religious exemption kind of policy put out after the fact, I would encourage you mainly to look into kind of whether that can apply to you after the fact here, and whether some things can get worked out to get you back in your classes. But anyway, in general, if there's, someone with a medical problem that might prevent them from getting the vaccine, or, a sincerely held religious belief, those are certain things that, can be looked into. Again, though, it's not as easy as just kind of raising your hand and saying, I've got a religious objection to this. I mean, you've got to kind of prove that it's sincerely held and all that. Yep.
What about like treating invasive species, right? So if we think about unwanted organisms, virus, not litter, but does the federal government have the right to regulate invasive species and the movement across state lines? And is that an area to explore as it relates to infectious disease?
And the question was, can the federal government regulate invasive species that cross state lines? And is that an avenue to explore in terms of a vaccine mandate? And that came from Kate Smith, good friends. But I do want to understand, Kate, a little bit about what your question is. Just, are you saying if the government can regulate invasive species that move across state lines, could that be a justification to say, well, the federal government can also regulate this virus that is crossing state lines? Yeah.
So if there's an species that kills trees and causes millions of dollars.
Yeah.
Economic damage and
Yeah.
trade.
Yeah.
I think the government can do that.
Yeah, and so, well, and the federal government has been doing a lot about COVID, as we've all seen. So to your point, I think what you've got to focus on is what's actually being regulated. And here, if you're talking about a vaccine mandate, if you're not talking about, the CDC putting out guidance, or, a lot of different things that have already happened that nobody's raised an objection to. Here you're talking about, again, a vaccine mandate. And like I said earlier, you're really talking about, number one, you're not regulating the virus, you're regulating people, but through their employers. So there's kind of an indirect route to it, which in and of itself kind of raises some questions about why is that being taken. The federal government can't do through our employers what it can't do directly. So in other words, if the federal government does not have the power to impose a vaccine mandate, then it can't just get around that by requiring our employers to impose a vaccine mandate. But again, what's actually being regulated here is us, workers, people who work, at least people who work in a place with 100 employees or more, getting a vaccine. And again, what you're really regulating is non-activity. You're saying you have not gotten a vaccine and you, Kate Smith, must therefore go get one. That's just very different than, regulating animals or invasive species that are crossing state lines, or doing things to combat the actual transmission of the virus across state lines, to identify, isolate, and destroy the virus, which is happening. Yes, the federal government can do that and has been doing that. So for example, the federal government can seize items that are crossing state lines and that are contaminated and destroy them. But in that instance, they're regulating the actual virus as it, crosses state lines. Here, I think what's being regulated is human beings. And again, it's not even activity, it's inactivity. And so that's why I think the NFIB versus Sebelius, what I kept referring to as the Obamacare decision, is such a good illustration of that, is because the federal government was trying to impose very similarly and, a mandate on citizens that arguably did affect interstate commerce. Not even arguably, it did. Just like you're saying, the virus kind of is crossing state lines and is affecting interstate commerce, is affecting the national economy. All of that is true. And so you've got to identify, though, at some point, when does that affecting interstate commerce argument run its course? And so it's almost like the butterfly effect. The butterfly, everything affects everything. If a butterfly flaps its wings here in America, it might cause a hurricane in China, and so the important things that we've been focusing on are that it's got to be activity that substantially affects interstate commerce. And I think those are where, here it just runs off the rails. You're trying to regulate human inactivity, basically. Yes. Yeah. So that's going to be, again, I talked earlier about, or kind of caveated at the beginning of this, that we're not talking, or at least I was not talking in the beginning of this about the federal government imposing this on federal employees. So that's going to be a very different situation. The federal government is going to have the authority to tell its employees, including the military members, to get vaccinated. Now, that's where you're going to get into, what I was speaking about with this other gentleman here at UMMC and their situation. You still do get into issues of First Amendment rights. So, and I'd like to back up too and say we're talking about two different things here. One is the power of the federal government. And then what you and I are talking about right now is kind of more about the rights of individuals, because once we've established that the federal government does have the authority to do something, or state government does have the power, just because they have the power to do something doesn't mean they can do it in all situations, because it might violate your individual rights. That's why the Bill of Rights is there. And so in that situation with members of the military, yes, the federal government does have the power to impose that, but there may be situations where the federal government can't impose that on specific service members, because they can demonstrate that they have a sincerely held religious belief that prevents them from getting the vaccine, or a health condition or something like that. Professor Green?
this, the mandate or regulation of inactivity. I imagine the fact that the final administration announced motion will be doing this, there's not any actual text of it.
Yeah,
But I imagine that the text would be something like, well, really regulating inactivity. What would be regulating the activity of running a business with more than 100 employees without having a vaccine mandate? So I'm wondering if you need to supplement the end of rule mandates with some sort of pretext rule. The way you're trying isn't ban running a business without vaccine regulation. What you're really trying to do is get people to get up and vaccinate.
yeah,
So, but if that's why, didn't we get rid of any kind of pre-tax analysis in Darby?
Yeah.
41 and the fall raptors, this is not the case, you go back to public, from overrule Darby on.
yeah.
That.
You're kind of the time law waits. So for those on Zoom, Professor Chris Green, one of my favorite law school professors, just asked some question that I'll simplify for us all. But basically, is to my argument that the government is really regulating inactivity and not even economic inactivity, just individual inactivity. The government would probably respond that they were not regulating individual activity. They were regulating the running of a business, how these large companies with more than 100 employees, how they have to run their business, which means to impose a mandate, a vaccine mandate. And then kind of got into some pretext questions, which basically just gets into, in this setting, the court is not necessarily going to look at whether the government is lying about their motives, essentially. And so I hear what you're saying, Professor Green. I think, of course, that's going to be an argument, just like there were a lot of arguments to the contrary, in NFIB versus Sebelius. I think the court will see, what's being tried to the U.S. Supreme Court. And one thing we haven't even mentioned here is that I think that the new makeup of the U.S. Supreme Court is going to have a big impact here. However you phrase it to try to obscure what's really happening, I think the court is going to look through that and say, yeah, you can, just like I said earlier to Kate's question, that, the butterfly effect, everything affects everything. I think there's a little bit of that going on here. I mean, yeah, you could say that we're going to, make businesses force all their employees to get a handgun because we think that will make America safer. I mean, we could go on and on. And so I think that one thing about it is that kind of raises also a necessary and proper clause argument. And so for everybody here, any power, well, the Constitution says that the federal government and Congress can use any method that's necessary and proper, can pass any law that's necessary and proper to affect any of the other powers that it's already been granted. And so to accomplish anything that it's allowed to accomplish under the Constitution. So, the first thing to point out there is that the federal government has to have the power to begin with. I mean, the necessary and proper clause does not grant it new powers. And so, I think that would come into play there. But even beyond that, I just don't think it's necessary or proper to use, workplaces to accomplish, again, what's very clearly an effort to combat the disease, not to really regulate the workplace. And I think that also goes, this is more of an Administrative, Procedures Act argument, but I think that also goes to the broader issues here, which is just that the act is designed to regulate the workplace. I mean, I really do think here you're talking about forcing people to, to do something outside the workplace, which has really never been done as far as I understand it. I think the only thing, and I'm not an expert on OSHA, like most people aren't, but looking into it a little bit lately, I think the only thing I could see was some kind of rule to maybe to deal with the ergonomics of home offices that was proposed and then never went anywhere. And so, in other words, we've never tried to use OSHA to regulate employee behavior or activities or anything outside the workplace. I mean, so we're not talking about here, how to make the building safe or how to, wear hard hats, in the building or on the work site or any of that. We're talking about, things that once they happen to you, you carry it around outside the workplace, you know, in your entire life. You know, you've made a medical decision here. And so I just think that's, you know, it's kind of like with the eviction moratorium decision we just saw. I mean, it's such a broad sweeping power that's being asserted here that I just think the U.S. Supreme Court is going to be very skeptical of it. Yes.
So what national advocacy groups on a national level are kind of rushing in to litigate this? That's question one. Question two, have you seen the ACLU's position on the vaccine mandate, and were you surprised? And where, just for the non-legal people, where, how do you see this playing out once it's litigated to its end?
Yeah. Sorry, the last part, and I'm going to repeat this for everybody on Zoom, but can you repeat the last part of the question again?
So advocacy groups.
Yeah. Well, the number 3, the last one.
Recently, timeline and do you see prevailing when this is all litigated to its?
Okay. Yeah. So we've got 3 questions. I think I'll just answer them because I think you'll get the for Zoom people. I think you'll get what the questions were, or I'll just do them as I go. One is what national organizations are litigating on this. I think Alliance Defending Freedom is working on this. If you're familiar with them, in terms of religious exemptions, there are probably some other kind of religious liberty-oriented nonprofit legal groups that are working on it. But I will tell you, I mean, I've been in discussions with a lot of those folks, and I kind of alluded to it earlier. It is very difficult to establish a religious exemption for most folks. I mean, there's, you know, again, if somebody's been getting vaccinated their whole life, and then this is the first time, you know, that they are upset about it, you know, that's going to make it very difficult to establish that this is a religious objection as opposed to an objection with this, a medical objection to this specific vaccine. And I know that that's important, having that medical objection, but the medical objection is not protected under the First Amendment to the U.S. Constitution, which is just a different scenario. And so, but anyway, backing up, I think First Liberty out of Texas too is looking into religious objection type things. And then there's some other groups I've talked to that are looking at kind of broader. I think college campuses, we're on one right now. I think that'll probably be kind of a battleground in some of the litigation, just because it tees up some of the issues pretty nicely for people who want to litigate them. I mean, you're talking about young, healthy people, and you know, which just kind of raises questions about the necessity of some of it. But anyway, we can certainly talk afterwards. I think ADF though and First Liberty are some groups that are looking at that. Second one, I'll go to the third one. Timeline, what's going to happen here with the Supreme Court? I mean, it'll take some time for this. I mean, you know, Department of Labor has to promulgate this regulation. They haven't even done that. We've alluded to that. I will say, and I think I've alluded to it already, depending on how it's worded, some of the arguments I made here today could get a lot weaker or a lot stronger depending on what comes out. So for example, I think one big way Professor Green was talking about an argument to get around a lot of my arguments. I think a big one that could be done is to say, oh, no, this isn't a vaccine mandate. This is a testing mandate. We're just mandating that everybody in the workplace get tested for COVID once a week. And, oh, but if you get the vaccine, that's an exemption. You don't have to get tested anymore. And so it's kind of backwards. You know, we're not going to mandate the vaccine. We're just going to mandate the testing. You know, I think that would certainly make it more defensible because it's, you know, there's less of a bodily integrity issue going on, and it's less of a sweeping power that's being asserted. But, you know, nevertheless, the federal government has to have the power to do anything it does, even if it's not as repulsive, or not even repulsive, but doesn't affect things like bodily integrity as much. And so I think for the same reasons, it would ultimately go the way I've predicted, but I think that would be a good argument for the government to make here that would make it a little more defensible. I'm sorry, I've lost track. Yeah. Well, yes, let me finish what I was saying. OSHA will have to promulgate this rule. That'll take some time. And, you know, there will probably be lawsuits filed the day that rule is issued by the Department of Labor. And so I think it'll take, you know, a year or so to get up to the U.S. Supreme Court. And then it'll take a while after that for, you know, the court to decide. So, I mean, we're probably talking about between a year and a year and a half. And then ultimately how it'll go. I mean, my prediction, and again, I do want to caveat that I'm making this prediction without having seen the rules. So, you know, take that for what it's worth. But just based on what's being discussed publicly, I think, especially with the new makeup of the court, I see it being struck down. And again, you don't have the tax power that you had, or the tax argument you had in NFIB versus Sebelius to kind of to save it, like save the individual mandate. And then the last one, ACLU. Yeah, yes, I've seen their position. I'm not surprised. I mean, for a lot of different reasons. But I'll go a little different direction with it. I mean, the ACLU used to advocate a lot on free speech, for example, and I have seen the ACLU kind of move away from that a lot. And so I think there's a lot of kind of new direction at the ACLU over the last few years, or decade or so. And so but I mean, I don't necessarily think that a federal vaccine mandate was something that the ACLU would have ever been concerned with, frankly. I mean, I think that even from the beginning, it was more about traditional civil liberty issues, around, again, free speech, which I'm sad to see kind of being ceded there, but political civil liberties, voting rights, things like that. So I don't know that a federal vaccine mandate is something the ACLU would have ever gotten really agitated about to begin with.
Eric, my question is about this sort of plausible intuition people have that the reason we have a federal government is to handle those unique set of problems that just states couldn't manage by themselves. And that's an intuitively plausible sort of position, that there are some things just individual states aren't powerful enough to accomplish. So we've got to have, a national government handle. And so what about someone who just says, look, I'm not a lawyer. I don't know how the federal government would write up a mandate, but it really seems to me that there ought to be a way that the federal government could do something about this, because this is exactly the kind of thing for which we have a national government, like an infectious disease that no state could deal with all by itself.
Yeah.
So I'm wondering I don't know if we can call this like the big picture complaint, or or just this basic intuition about the nature of federal government in general. What do you say to someone like that?
I totally agree with you, and I'll just briefly kind of rephrase the question. Is just, what about people who think just kind of intuitively that the federal government is kind of our largest just branch of government? It's really its own separate government that has the unique kind of ability to deal with something like a virus that crosses state lines, and that state governments aren't necessarily equipped to handle on their own. And someone just thinks, shouldn't the federal government just be able to do that? So the counter to that is really, I mean, it's fundamental to who we are as a country and the way the Constitution was set up. And I'll explain why it was set up that way. Some of the reasons for that. We talked earlier about the limited government that the power has, and then the kind of broad plenary authority that the states have. And that's called federalism, and the founders very much wanted us to be a federalist system. But why? To your question, why does it matter? I mean, the reason it matters is because we wanted to have the powers that were going to be exercised that affected your life the most. Like I said earlier, your schools and zoning decisions and public health and safety, to be made closer to you, so that people weren't kind of subject to the whims of this far off bureaucracy, that they had no meaningful ability to kind of, petition or change the decisions being made, and that it would affect your life, every day. And, the honest truth is that we have kind of gotten closer to that, where the federal government does have a lot more authority. And so there's a lot of reasons for that. We talked about the Commerce Clause being kind of expanded by the U.S. Supreme Court. Also, our national economy has just grown so much that it's made the Commerce Clause, be able to be used in a lot more settings than it probably could have been back then. But, you've also got, because of the taxing power that Congress has, and the amount that it taxes, the huge amount that it taxes, and thus the huge amount of money that it brings into DC, it's been able to constitutionally use that money to kind of, up to a point, you can't coerce the states too much, but up to a point has been able to kind of co-opt the states and say, well, you better raise your drinking age to 21 or you don't get your highway funds, and so we have kind of seen the federal government become kind of the leading entity when it comes to a lot of these things. But anyway, at the end of the day, I mean, you want a government closer to you to be making those decisions. And I think we can see that today, you know, with how divisive and partisan a lot of things have gotten. And it almost seems, you know, sometimes like the country's about to rip apart. I think people can maybe understand the benefit of that a little more. You know, I mean, do you want, you know, if you're, you know, super pro-choice, do you want to live in California and have people, you know, and especially when we get past some of the upcoming Supreme Court decision and depending on what happens there, but just take an issue like that, you know, do you want to be able to live in California and have, you know, people that run California making those kind of decisions, or if you're very pro-life, maybe live in a place like Mississippi, and, you know, that's the reason that you want state governments and even local governments making those decisions that impact you so much. So that's the reason. Now, in terms of just the power or the ability of those different government entities to handle it, I think there's a valid point there, just because, again, the federal government has gotten so large over time. But, you know, you've got state governments can cooperate, can pool resources. You can also have the federal government fund a lot of what the states are doing, which we've already seen. And so, I mean, I think there are ways to accomplish this, but what you're going to see, and what, you know, depending on where you land, you may not like, is if you do it that way, you're going to see what the founders intended, which is some states might have vaccine mandates and some states might not. And that's the beauty of it. That's what you really want. And that's what we kind of lose, is that, you know, 50 laboratories of democracy where we could see if 50 states did it 50 different ways, we could see what worked, you know, and maybe some states have really strong mandates, some have really weak mandates, some only mandate testing, some mandate, you know, the full, you know, get the vaccine, everything. And then some states don't have any mandates at all. I mean, you can have a lot of different ways of doing it. We might be able to learn from that and see, oh, well, New York did it really well, or Texas did it really well. But if you take a national approach, you lose that, you lose the ability to kind of experiment with public policy, and you just have people subject to, you know, this far off bureaucracy making those decisions for them instead of a local government that they, you know, I know, you know, a good many of our state legislators, you know, and so, I mean, I can, and even if I didn't, it's not that far away to Jackson, or I live very close to Jackson. And, you know, we can find out who those people are and talk to them and make our voices heard a lot more than, you know, to Washington, D.C. So that's the reason. Yes, sir.
Issue of colleges and universities that are imposing mandatory vaccines. Back in August, the Seventh Circuit three-judge panel ruled that they would not block Indiana University imposing that on their students. And the state, and two of those three judges were appointees by then President Trump. Yeah. Then Amy Coney Barrett, who is the assigned justice for the Seventh Circuit, followed suit and said, "I will not block this this mandate." Yeah. What's your reaction to that?
So the question was that the Seventh Circuit looked at a college and university vaccine mandate and upheld it, and even Amy Coney Barrett, who was assigned to that decision and is the recent appointed to the U.S. Supreme Court, also did the same thing. And my reaction to that, the reaction is not surprising at all. And so, you know, going back to kind of the beginning of this talk, state powers. And so a state university is not in the same position, you know, at all as the federal government. And so you've got that, you know, Jacobson 1905 case that we talked about, that smallpox case. And so, you know, we do have, I mean, I'll say this, that Jacobson opinion was cited by Chief Justice Roberts kind of early in the pandemic, as you probably saw. And a lot of judges kind of ran wild with it and started using it in a lot of contexts that I don't think they should have. So in other words, First Amendment cases. So the First Amendment had not even been incorporated against the states to the 14th Amendment back in 1905 when that decision was rendered. But just kind of using Jacobson as a complete, you know, catch-all, like, hey, the government can do anything it wants during COVID, which I think was not a wise way to use that. But the opinion, you know, is good law, and there's some things that have changed since then that could be looked at by the U.S. Supreme Court, but it's still good law. And, you know, what it ultimately stood for is that the state does have the power, not the federal government, but again, state governments that have that broad police power do have the authority to impose vaccine mandates. And so if you're talking about a state-funded university, you're falling more into that bucket of state powers, not federal powers. Yes, Professor Green.
Non-delegated. So even if the OSHA Act
Yeah.
was, that would be functionally the transfer of legislative power.
Yeah.
Well,
Yeah. And I've got two different answers to that. So for Zoom, the question from Professor Green at the law school was about non-delegation doctrine, which I'll just explain in my answer. But I think, again, I said I've got two answers. I think personally, my answer is that I would love to see the non-delegation doctrine, kind of revived and enforced a lot more. And the non-delegation doctrine basically just means that branches of government can't delegate their authority to other branches of government, or, at least there's a lot of limits around that. And so the question here being, if Congress did have the power under the Commerce Clause, if I'm wrong about all that, if Congress does in fact have power under the Commerce Clause to impose a vaccine mandate, but again, we're not talking about Congress doing this, we're talking about the Department of Labor doing this. And so would you still have a problem of just, even if Congress did have the power, the fact that they, through this OSHA Act, would be arguing that they delegated that power to the Department of Labor? Would that be a problem under the non-delegation doctrine? And again, my answer is twofold. I think yes, and I would love to see the Supreme Court interpreted that way. Professor Green, you know a lot better than I do, but my understanding is the non-delegation doctrine has kind of fallen out of favor with the U.S. Supreme Court. Maybe with the new makeup, it'll come back around. But my answer is yes. Personally, I think that would be a major constitutional problem, and I would love to see the U.S. Supreme Court go that route. But also because of the doctrine of constitutional avoidance, I don't think they will if they rule on the Commerce Clause. And I would much rather them strike it down under the Commerce Clause, really. So, yes, sir.
In the school of journalism.
John?
This Springfield campus since the beginning of the semester, so I know that might be kind of hard for you to comment to a university question.
What? Following what story?
So it might be kind of hard for you to answer a university specific question.
No.
So at the very beginning of the semester, the faculty senate passed the resolution to mandate the COVID-19 vaccine on campus, and then just 2 weeks ago in this very same room, the ASB student government also passed that same resolution. But it wasn't until a few days later that IHL kind of struck that down and ended that conversation.
Yeah.
So there's a lot of readers that are still wondering what happens next. So is that just kind of like a one and done situation, or if action were taken by lawyers like yourself, how long would that take and what would that look like?
Yeah, so the question was, there's been interest by the faculty senate at Ole Miss and by the student senate, or whatever it's called here, to have a vaccine mandate on campus. And then recently, IHL, the Institute of Higher Learning, passed a resolution or whatever type of things they passed. I think it's called a resolution. They basically said state universities in Mississippi cannot have vaccine mandates on campus. And then I think the question was basically, will there be lawsuits about that? And if so, what are the prospects of those lawsuits to challenge that rule from IHL? Is that the question?
So just to kind of answer that question of what happens next, and is that conversation completely?
Okay, so the question was what happened next, and is the conversation basically over? I mean, I think from a practical standpoint, that probably ends it. I mean, IHL, as you're aware, I mean, is the authority over the universities. And, I would want to go back and look at the statute again. It's been a while since I've looked at it, that sets up the IHL and the exact powers that it has. But I think it's pretty broad over, what the powers it has by statute over the universities. And so, just briefly, yeah, I think if IHL doesn't want a vaccine mandate on college campuses in Mississippi, there probably won't be one. Now, could there be some arguments by individuals in litigation? Maybe. I'd have to think through that a little more. no successful arguments are coming to mind, because here you're not talking about trying to stop government action. You'd be talking about kind of trying to compel government action. Now, I guess you could say you're challenging the act that the IHL took, and whether it really has the authority is what you'd be doing. That wouldn't be necessarily a constitutional argument you'd be making, or that anybody would be making. It'd be more of a statutory argument. They'd just be saying IHL under the Mississippi Code doesn't have the power to do what they did here. And frankly, I would need to go back and look at the IHL statute to know more. But my recollection of that statute is that IHL has a lot of authority when it comes to the university. So I think that's probably the end of the road on that.
I'll be a final question. All right.
Yes, sir.
Words or phrases in the Constitution, what they mean, and or do you think there's more value in saying like this is what these cases in the past have determined these words to mean?
Yeah.
You prefer like looking into the document?
Yeah. So
What the founder at the time meant, and I guess do you think it really matters, or should it just
it matters, yeah. I'll try to keep it brief on that, but it's a great question. It's a great question. I know that's what I was about to say is we could talk for, days and days and days about that. So question was, what do you think about the words in the Constitution, how you interpret them, how do you interpret them, and how much weight do you give to past precedent that the U.S. Supreme Court has made, or, different methods of looking at what the founders really meant by the words and things like that. What you're really asking there are entire schools of thought on all of that, on the proper method of judicial construction of what the Constitution means. And that's the entire reason we have courts, not the entire reason, but one of the main reasons we have courts is to interpret, what the Constitution means, and statutes as well. I mean, it's really not a simple task. I mean, you put words on paper, but then how do you apply those words to specific situations like this federal vaccine mandate? What do those words mean? But there are reams and reams and reams of philosophical type arguments and other types of arguments on how we should interpret the Constitution. And you referenced stare decisis is what it's called in terms of deferring to past precedent. There's arguments for and against that. I mean, the reason we have that is basically to provide stability, especially to a big country like America. But regardless, if the Supreme Court was changing its position on things every other day, nobody would kind of know, is abortion legal? Is it illegal? Am I going to get in trouble if I have an abortion today or not? And so, stare decisis in large part is an effort to try to provide stability to the law. Everybody knows, we know how the court has dealt with these issues. We can predict how it will deal with similar issues. So that's why you've got stare decisis. But anyway, in terms of also just looking at what the founders meant and all that, I mean, there's a lot of schools of thought on that. And I mean, I personally think that yeah, I mean, what the founders, meant by the words is very important. I mean, some people who kind of more living constitutionalists would think that matters less. What, the old dead white guys that wrote it, hundreds of years ago, what they meant or thought is less important than how it could be applied today. And so that's just it's a very lively debate. I mean, maybe you'll go to law school and have a lot of opportunity to debate that for years and years, or the rest of your career. But it's a great question. It's just something, we could talk about for days.
All right, Aaron, thank you so much.